5 seconds to go. Start. The non-application of the general strict liability principle in case of an insurance policy is sought to be questioned where an expanded meaning has been given to the relevant term of the insurance policy in order to grant insurance claim now assailed before us by the insurance company. The appellant herein, in view of the order dated 3rd October 2017 passed by the Division Bench of Patna High Court in favor of respondent number 1 herein. The original claim was made by a writ petition filed by the prospective beneficiary, that is, respondent number 2 herein, but while granting the benefits to the beneficiary, a liability was placed on respondent number 1 and not on the insurance company, which aspect was reversed by the Division Bench vide its judgment dated 3rd October 2017, fastening the liability on the insurance company. The appellant insurance company and respondent number 1, the Chief Electoral Officer Bihar Patna, entered into a memorandum of understanding hereinafter referred to as MOU on 9th February 2000 to provide insurance cover to the persons deployed for election-related work for Bihar Legislative Assembly elections in the year 2000. The relevant clause in question of the MOU is Clause 3, which reads as under. The insurance is intended to provide for the payment of compensation in the event of death only resulting solely and directly from accident caused by external violent and any other visible means. On the MOU being executed, the state government opted for a group insurance scheme vide letter dated 10th February 2000 to cover its premium paying employees who were appointed for election related activities. It appears that, keeping in mind the period of the by-polls, the duration of the insurance scheme was extended from 24th May 2000 to 23rd June 2000 by way of a supplementary policy. The incident we are concerned with was during these by-poll elections. The husband of respondent number 2, late Deval Ravidas, Constable Shivhar District Force, was a member of the Static Armed Force posted at booth number 67 Primary School, District Vaishali, who died due to a sunstroke, heat stroke, while performing election duty for the Bihar Legislative Assembly. As stated, this was during the extended period of the insurance policy. It appears that the matter rested at that for a fairly long time, and it is only in the year 2008 that respondent number 2, wife of the deceased Constable Deval, sought to raise the issue of compensation vide her letter dated 21st November 2008. The Assistant Election Officer Bihar come Under Secretary to the Government vide letter dated 20th November 2009 addressed to the Under Secretary to the Lokayukta Patna Bihar noted that the death of the deceased constable had occurred on account of heat stroke on 26th May 2000 during election duty and had not occurred on account of any external violent activity accident. Thus, compensation to respondent number 2 could not be found admissible for payment. Respondent number 2 wife filed a writ petition being CWJC number 1781 of 2011 before the High Court of Judicature at Patna for quashing the aforementioned letter dated 20th November 2009 and sought payment of compensation amount of rupees 10 lakhs as per the insurance policy since her husband had died while performing election duty. Apparently on account of some directions of the learned single judge, the district election officer placed a notice of claim dated 24th April 2011 to the appellant insurance company regarding the claim for insurance. This was, however, not accepted. The learned single judge in the writ petition CWJC number 1781 of 2011 decided not to go into the issue whether the accidental death was in terms of the policy because the Chief Electoral Officer in a supplementary counter affidavit had already acknowledged the eligibility for payment to the wife of the deceased police official. The court, relying on the judgment in Leelavati Devi versus the state of Bihar and others, opined that after the expiry of a given policy, no direction could be given for payment of insurance amount. The claim was required to be lodged within the duration of the policy, that is 24th May 2000 to 23rd June 2000. Thus, the court opined that the primary responsibility to raise the claim under the policy was with the officials of the state government and that they did not raise the claim within the duration of the policy and permitted the policy to lapse. Therefore, the liability to pay the amount to the deceased wife was assigned to the Chief Electoral Officer and the District Magistrate Vaishali. The Chief Electoral Officer preferred an appeal before the Division Bench of the High Court against the order dated 17th May 2011, which is the subject matter of the impugned judgment dated 3rd October 2017. In LPA number 1049 of 2011, insofar as the insurance company is concerned, it washed its hands of the liability, relying on the judgment in Leelavanti Devi case. Thus, primarily, the defense was raised on the absence of any claim being lodged in time, though the death of the police constable during the election period of by poll was not disputed. Stop.